Hi everyone, today we are going to discuss about National Green Tribunal. The National Green Tribunal was established on 1810-2010 under the National Green Tribunal Act of 2010. The scope, the objective of establishing a National Green Tribunal are as follows. 1. To provide effective and expeditious disposal of cases relating to environmental protection and conservation of forest and other natural resources, including enforcement, protection, and conservation of forest and other natural resources, including enforcement of any legal right relating to the environment, giving relief and compensation for damages to persons and property, and other related matters. Now, the tribunal is dedicated jurisdiction in environmental matters. The NGT, that is National Green Tribunal, is established for effective and expeditious disposal of cases relating to four categories, that is environmental protection, conservation of forest, enforcement of any legal right relating to environment, and the fourth one is giving relief and compensation for damages to persons and property. So once again, NGT has four main objectives, that is environmental protection, conservation of forest, then enforcement of any legal right relating to environment, and the fourth one giving relief and compensation for damages to persons and property. The NGT has the power to hear all the civil cases relating to the environmental issue and the questions that are linked to the implementation of the law listed in Schedule 1 of the NGT Act. These include the following. So NGT was brought into existence in 2010, and NGT has the power of as a civil court to hear all matters relating to environmental issues and questions that are linked to the implementation of laws listed in Schedule 1. So what are the laws listed in Schedule 1? So that is the Water Prevention and Control of Pollution Act of 1974, the Water Prevention and Control of Pollution Cess Act of 1977, now the Forest Conservation Act of 1980, the Air Prevention and Control of Pollution Act 1981, the Environmental Protection Act 1986, the Public Liability Insurance Act 1991, the Biological Diversity Act 2002. So all these laws, any question linked to the implementation of these laws will be dealt by NGT. Now, with the enactment of NGT Act, civil courts cannot hear matters related to environmental issues under the 7 laws which the NGT is empowered to deal with. We already discussed these 7 laws, that is the Water Act, the Water Cess Act, the Forest Conservation Act, the Air Act, the Environmental Protection Act, the Public Liability Insurance Act, then the Biological Diversity Act. These are the 7 acts referred here. Now, however, the NGT has not been vested with powers to hear any matters relating to the Wildlife Protection Act. So, though we have Forest Conservation Act under the 7 acts mentioned, NGT does not have any powers vested in it to hear any matters relating to the Wildlife Protection Act of 1972, the Indian Forest Act of 1927, and various laws enacted by states relating to forest, tree preservation, etc. So those are state laws. Now, a claim for compensation can be made for 1. Relief or compensation to the victims of pollution and other environmental damage, including accidents involving hazardous substances. And the second one is restitution of property damaged. And the third one, restitution of the environment for such areas as determined by the NGT. So we have 3 kinds of relief or claim that can be made under NGT. The first one is relief or compensation to the victims of pollution and other environmental damage, including accidents involving hazardous substance. The second one, restitution of property damaged, and the third one, restitution of the environment for such areas as determined by the National Green Tribunal. Now, why the National Green Tribunal came into being, or what was the necessity for it? National Green Tribunal is a specialized body equipped with the necessary expertise to handle environmental disputes involving multidisciplinary issues. So they are a specialized body and they have the expertise to handle anything that is related to environmental, and that is in a multidisciplinary issue. The tribunal shall not be bound by the procedure laid down under the CPC. So the National Green Tribunal does not follow the procedures under CPC, but it is guided by the principles of natural justice. It will be relatively easier for the conservation groups to present the facts and issues before NGT, including pointing out technical flaws in a project or proposing alternatives that could minimize environmental damage, but which have not been considered. NGT aims to provide speedy environmental justice and help reduce the burden of litigation in the higher courts. The tribunal is mandated to make an endeavor for disposal of applications or appeals finally within 6 months of filing of the same. So there is a time, but it's a time bound process, and the time given is 6 months from the filing of the case. The petitioner can argue the matter before the NGT themselves. So, to argue a matter, the petitioner need not seek an advocate. The petitioner can argue the case before NGT themselves. Now, the seats. Initially, the NGT is proposed to be set up at 5 places of sittings and will follow circuit procedure for making itself more accessible. New Delhi is the principal place of sitting of the tribunal, and Bhopal, Pune, Kolkata and Chennai shall be the other 4 places of sitting of the tribunal. There is also a mechanism of circuit benches. For example, the Southern Zone bench, which is based in Chennai, can decide to have sitting in other places like Bangalore or Hyderabad. So initially there was only 5 seats. The principal one was in Delhi, the others were in Pune, Kolkata, Chennai and Bhopal. Now the chairperson of NGT is a retired judge of the Supreme Court. So who is the chairperson of the NGT? He is a retired judge of the Supreme Court headquartered in Delhi. Now other judicial members are retired judges of high courts. Each bench of the NGT will comprise at least 1 judicial member and 1 expert member. The expert members should have a professional qualification and a minimum of 15 years experience in the field of environment or forest conservation and related subject. Now, procedure for filing an application or appeal. The NGT follows a very simple procedure to file an application seeking compensation for the environmental damage or an appeal against an order or decision of the government. An application can be filed using a simple template available in the NGT website. For every application or appeal where no claim for compensation is involved, a fee of 1000 rupees is to be paid. That is, if there is no claim for compensation. Now, in case where the compensation is being claimed, the fee will be 1% of the amount of compensation subject to a minimum of 1000 rupees. So there are 2 situations. The application is available on the NGT website, and if the claim is based on a compensation, it has to be the fee will be 1% or the minimum of 1000 rupees as the application fee, and if there is no compensation claimed, then the fee will be 1000 rupees. That is for an application as well as an appeal. No application for grant of any compensation or relief or restitution of property or environment shall be entertained unless it is made within a period of 5 years. So what is the limitation here? That is the 5 years. So any grant of compensation or relief or restitution of property or environment shall be entertained only if it is filed within a period of 5 years. The 5 years from the date on which the cause for such compensation or relief first arose. The official language of NGT is English. Now, principles of justice adopted by NGT. The NGT is not bound by the procedure laid down by CPC, but shall be guided by principles of natural justice. Further, NGT is also not bound by the rules of evidence as enshrined in Indian Evidence Act 1872. So, in short, NGT doesn't follow the procedures of CPC and they are not bound by the rules of evidence by Indian Evidence Act. Thus, it will be relatively easier as opposed to the approaching a court for conservation groups to present facts and issues before NGT, including pointing out technical flaws in a project or proposing alternatives that could minimize the environmental damage but which have not been considered. Now, while passing orders or decisions or award, the NGT will apply the principles of sustainable development, the precautionary principle, and the polluter principle. So, there is the principles of sustainable development, precautionary principle, as well as the polluter principle, polluter pays principle. So, these principles will be applied by the NGT. However, it must be noted that if the NGT holds that a claim is false, it can impose cost, including lost benefits, due to an interim injunction. Now, under Rule 22 of the NGT rules, there is a provision for seeking a review of decision or order of the NGT. If this fails, an NGT order can be challenged before Supreme Court within 90 days. So, under Rule 22 NGT rules, there is a provision for seeking for a review of a decision or an order. Now, if that fails, the NGT order can be challenged before Supreme Court within 90 days. Now, if a project, proponent, or any authority does not comply with the directions contained in an NGT order, the penalty can be imprisonment for 3 years or fine extending to 10 crore or both. Now, continued failure will attract a fine of 25,000 rupees per day. So, initially there will be a penalty of imprisonment of 3 years or fine of 10 crore or both. And if the non-compliance is continuous, then it will attract 25k punishment per 25k penalty per day. Now, the landmark judgment from National Green Tribunal is Miss Betty C. Alvarez versus the state of Goa. Yeah, that is, even a foreign national can approach the NGT. So, even a foreign national can approach NGT. That was laid down by Betty C. Alvarez versus state of Goa and others. That is a 2014 case. Now, in another case, that is Srinagar Bandh Aapda Sankarsh Samiti. Srinagar Bandh Aapda Sankarsh Samiti and others versus Alaknanda Hydropower Company Limited. Now, that is a 2016 case. Here, NGT has directly relied on the principle of polluter pays and made a private entity liable to pay compensation, making them subject to a code of environmental jurisprudence. Now, another case is Save Mon Region Federation and others versus Union of India, again a 2016 case. Here, the tribunal very proactively suspended the environmental clearance granted to the project and directed the EAC to make a fresh appraisal of the proposal for environmental clearance grant and asked the Ministry of Environment and Forest to make a separate study on the protection of the said bird. Now, another Yamuna Conservation Zone case, that is 2014. Here, NGT stopped construction of the proposed recreational facilities in the 52-kilometer stretch of Yamuna, Iron, Delhi and UP. Now, there is ban on all vehicles in Delhi, that came in 2015. So, NGT banned diesel vehicles over 10 years and old after a WHO study found Delhi to be the most polluted city in the world. That was in 2015. That is ban on all old vehicles in Delhi. That is 2015. Now, there are also some challenges that is faced by NGT. The first one, lack of proper infrastructure. Now, the number of environmental cases has been on the rise, but due to lack of benches and infrastructure, the body is unable to pronounce its judgment on time. The second one is lack of appointments. The body should have minimum 10 judicial and expert members, out of which only 2 judicial members and 4 expert members have been appointed till date. Now, the third one, the inefficiency of central and state pollution control board result in delays in implementing the tribunal's decision. And the fourth one is the tribunal is not having suo motu powers, which also restrict its ambit in the area of environment. So what are the challenges faced by NGT? That is, one is the lack of proper infrastructure, then there is lack of appointments, then the inefficiency of the central and state pollution control boards, then comes the lack of suo motu powers for the NGT. So that is with NGT. It came into being in 2010, and the National Green Tribunal was established in 2010 under National Green Tribunal Act of 2010. So that is with this session. Thank you for listening. Like, comment and subscribe. Please click that bell icon so that you can stay updated when I upload my next video or a podcast.